Hello, my name is Amanda Carpenter. I serve as a municipal counselor for the City of Oklahoma City. I am also a member of the Oklahoma Association of Municipal Attorneys, the OAMA for short. One of the missions of OAMA is to provide those across the state of Oklahoma that are practicing in municipal law with resources to assist them in providing sound advice to cities and towns they represent. OAMA has established a program that provides such information accessible through the OAMA website, www.okmunicipal.attorneys.org. In an earlier segment, we discussed the Governmental Tort Claims Act and its applicability to cities and towns. With the adoption of the Tort Claims Act, the Oklahoma legislature reasserted the concept of sovereign immunity, a governmental entity's immunity from liability for tortious conduct of its employees, and then provided a limited waiver of that immunity if both the substantive and procedural rules of the Tort Claims Act were followed by the claimant. This segment is part 2 of our look at the Tort Claims Act and focuses on the specific exemptions from the liability that are enumerated in Section 155 of the Tort Claims Act. Originally, the legislature enacted the Political Subdivision Tort Claims Act of 1978 that laid out the structure of how claimants that were injured by tortious conduct of a governmental employee could seek relief in certain circumstances. That 1978 Act was replaced by the 1985 Governmental Tort Claims Act. Since 1978, there have been over 20 amendments to the Tort Claims Act. The Tort Claims Act represents the efforts of the legislature to set public policy in the area of law that seeks to balance the monetary strain on public funds from those allowable tort claims, providing when and what level of relief will be available to injured claimants. One legal scholar, when the Governmental Tort Claims Act was enacted in 1985, categorized the 28 exemptions for liability into 4 different categories: governmental, police and military, transportation, and miscellaneous. There are now, in 2020, 37 listed exemptions. Because there are such a large number of exemptions, for this presentation, I'm going to focus on the 4 categories previously introduced. Governmental exemptions. This category of exemption focuses more on what are considered basic governmental functions that involve the use of judgment or discretionary actions, which are considered essential for the government to function. Often, governmental decisions are politically contested decisions, such as legislative actions or actions that require finality, respect for a decision, or where the ability to sue regarding a decision one simply does not agree with would bog down the system and make it unworkable. Those exemptions in this category cover the following: legislative, judicial, quasi-judicial, or prosecutorial functions, execution or enforcement of any lawful court orders, adoption or enforcement of, or the failure to adopt or enforce any law, whether or not such law is valid, assessment or collection of any taxes or fees, licensing or inspection powers, claims relating to the placement of children, discretionary powers or functions, court-ordered community sentence. Governmental actions that fall into these areas, even if tortious or injurious to others, are still shielded by sovereign immunity due to the specific exemptions found in the Governmental Tort Claims Act. A second general category of exemptions recognizes that there are certain circumstances where the police or fire department and military need to be able to act and react without exposure to civil liability. Those exemptions are outlined as follows: civil disobedience, riot, insurrection or rebellion, or the failure to provide or the method of providing police, law enforcement, or fire protection, express or implied lawful entry into any property, operations at any correctional or incarceration facility, related to any court-ordered or court-administered work release program, activities administered by the Military Department of State during a riot, national disaster, or military attack, provision, equipping, operation, or maintenance of any juvenile detention facility, or injuries resulting from the escape of a juvenile detainee, or injuries by a juvenile detainee to any other juvenile detainee. Governmental actions that fall into these categories, even if considered tortious or injurious to others, are still shielded by sovereign immunity under the Oklahoma Governmental Tort Claims Act. The transportation and weather category of exemptions recognizes a very practical consideration of not holding government entities liable under certain circumstances. Those include weather conditions over which the government has no control, whether to initially construct a particular roadway or public work project, whether to initially place a traffic control device at a particular location, from roadway defects in which the government entity has no notice and a reasonable time to either correct the problem or warn of the potential hazards. There is also a special exemption for state highways whose conditions remain unchanged since 1985. Those exemptions include accidents or events occurring on public ways or in public places due to the weather conditions, claims or losses resulting from the maintenance of state highways, claims or losses relating to operation or non-operation of traffic signs, unless that failure to correct is beyond the reasonable amount of time after notice. The initial placement, alteration, or change of traffic signs or signals based on the fact that such decisions are discretionary. Actions or recoveries against the Oklahoma Transportation Commission from pre-existing defects or dangerous conditions, whether known or unknown, from the effective date of the act. Governmental actions that fall into these areas, even if tortious or injurious to others, are still shielded by sovereign immunity under the Oklahoma Governmental Tort Claims Act. The next set of exemptions are miscellaneous and do not fall into any of the three prior categories, but do provide significant protection to governmental entities for the torts of its employees that arise in all of these situations. Workers' compensation or employee liability acts, as they are separate statutory authority to cover these situations. Claims which are limited or barred by law. Acts or omissions that conform with then current recognized standards. Acts or omissions of independent contractors. Product liability or breach of warranty. Theft of money left in the custody of a government employee. Attractive nuisance. Unintentional misrepresentations. Natural condition of unimproved property. And claims arising from interscholastic or athletic contests. Government actions that fall into these areas, even if considered tortious or injurious to others, are still shielded by sovereign immunity under the Governmental Tort Claims Act. In addition to the exemptions from liability that were enumerated in 1985 with the passage of the Oklahoma Governmental Tort Claims Act, there have been a handful of additional exemptions added by the legislature since that time. Those include additional school protections, participation in approved activities in school buildings or on grounds before or after normal school hours, or on weekends of indoor and outdoor school property, and facilities made available for public recreation before or after normal school hours or on weekends and school vacations. School district employees for controlling a student during school or in transit or other authorized school function, the out-of-school suspension of a student, the use of a public facility open to the general public during an emergency, action and related maintenance of property under environmental remediation requirements of either state or federal environmental agencies, indemnification or subrogation. Like the others discussed, governmental actions that fall into these categories, even if considered tortious or injurious to others, are still shielded by sovereign immunity under the Governmental Tort Claims Act. One final note. Since the Tort Claim Act is a public policy statement by the legislature concerning the extent of the waiver of sovereign immunity, it is very important that in defending your city or town that you pay close attention to cases that construe or compare the meaning of specific provisions of the Tort Claims Act. In its time since 1978 and then in its replacement in 1985, there have been many instances where a particular construction of the Tort Claims Act language by the Oklahoma appellate courts was followed by a change in the language of the Tort Claims Act by the legislature. A fairly recent example of this dynamic is highlighted in the case of Payne versus Kern. In that case, a prisoner brought an action against sheriff and county jail administrator alleging civil rights violations, including violation of state constitutional prohibitions against cruel and unusual punishment. The Oklahoma Supreme Court held that the prisoner had a private right of action for cruel or unusual punishment at the time of his delayed release because the tort occurred prior to the legislative enactment of barring the constitutional torts under the Governmental Tort Claims Act. The enactment occurred in Bosch versus Cherokee County Governmental Building Authority, where the Supreme Court case recognized a separate Oklahoma constitutional tort was not addressed by the Oklahoma Governmental Tort Claims Act. So the tortious conduct occurred during a narrow period of time between when the Oklahoma Supreme Court recognized a private action and the Oklahoma legislature, as a matter of public policy, amended the language of the Tort Claims Act to close that window. It is important to compare the language construed in cases to the language in the statute at the time the tortious conduct is alleged to have occurred. Again, my name is Amanda Carpenter. I serve as a municipal counselor for the City of Oklahoma City, and I am also a member of the Oklahoma Association of Municipal Attorneys. The mission of OAMA is to provide those across the state of Oklahoma participating in municipal law with resources to assist them in providing sound advice to cities and towns they represent. OAMA has established this program with information on its website, www.okmunicipal.attorneys.org. There you will find the names and contact information of OAMA board members and their partner organizations, such as Oklahoma Municipal League, Oklahoma Municipal Management Services, the Oklahoma Municipal Assurance Group. If you are a municipal law practitioner, please take advantage of these resources, and you are certainly invited to consider OAMA membership.